Hi everyone. So I'll just introduce myself first. So I'm Dr. Anchal Dua. I take care of the delivery and operations for all our programs at EBC Learning. And we have already launched four courses. One is IPR, ADR, contract drafting and aviation, and IPR is one of the 6 month certificate course. Yeah, so we'll just go ahead with the introductions first. If you're fine with that, so Pooja, we'll go ahead with you first. Hi, Pooja. If you can unmute yourself and introduce, you can put your brief introduction on the chat as well if you're not too comfortable in putting it yourself on unmute. So I'll just quickly take you through once you take the program with us, you would be registered with us for the 6 month certificate course in IPR. You can enroll with us by 31st of December 2025, and the start date for the course is 1st of January 26. End date, again, it's a 6 months course. So the end date, it's a 26-week course. The end date is 1st of July 2026. The effort which should be required from your end is about 6 to 8 hours per week. The price which we have quoted now is 15,000. If you can want to take an early bird offer, the price is reduced to 2,000. So that was the brief about how you can,
So, good evening, everyone. So, I see a couple of participants like Pooja, Prem, Vaibhav. Hello, thank you for joining in. I would definitely like to know your backgrounds. I mean, are you all practicing lawyers, or are you law students, or do you even belong? Are you lawyers or non-lawyers? I would like to understand my audience. So, a quick you can even type it on chat as to what you guys do so that we can take the discussion forward, and again also of course help you understand the upcoming course a little more in detail. Okay, Vaibhav is a final year law student and an annual subscriber. Oh, excellent. All right. What about Pooja, Prem? Pooja, I hope you can hear us, and also Prem. You can just type on the chat box whether you are lawyers, non-lawyers, law students, whatever uh, backgrounds that you come from. Prem is a lawyer. Okay, excellent. For those of them joining now, we are just going through a round of quick introduction. It would be fantastic if you could just come online, audio, video, everything. If it's not very comfortable for you, you can just type on the chat box as to what you do. Are you lawyers, non-lawyers? If you are lawyers, are you practicing, or are you law students, or whatsoever it is? You can just introduce yourselves and we can take it forward. Just 1 minute of quick introduction. Arjit is a practicing lawyer. Okay, fantastic. Do any of you work on the IP space? IPR lawyers? Prem, Arjit, do any of you work on the IPR front? Any matters relating to IPR? No. Okay. But maybe this will open up a lot of ideas to you in terms of what you can think of in the context of exploring opportunities in the area of IPR. And that's precisely why we have this particular program as well. So, this is a sort of a prelude, I would also say. In terms of us exploring intellectual property rights as an area of practice, and what are the new dimensions that we have. Even if we studied IPR as law students, right, a couple of years back, much has changed. As simple as giving examples also of, even as simple as saying, what is a copyright? What comes as a literary work under copyright? So we always said books, poetry, or lyrics of a song, etc. But today we can include within the ambit something like an online gaming narrative, right? Or a performance script, a virtual reality performance script. So this can be something which becomes a part of the literary copyright work today. So a lot of new dimensions in the digital age that we are seeing in the context of intellectual property rights, which is precisely the topic for the day. And this will only open up a few new dimensions, but the core of this particular course is to give you that solid foundation so that you are able to navigate yourselves through the challenges of intellectual property in the present time and age. I'm going to keep this very interactive. I know it will be a little difficult for you all, but you can please use the chat box and chat with me. This is more of interactive session. Okay, I have a small quick presentation for you, and I will run you through the presentation and continue with my discussions. All right, so I'll just get started with some basic illustrations. Okay, there is a lot that we are seeing in the present time and age in terms of AI being used, right, in terms of creativity, in terms of innovation, by whatever name we want to call it as. So, this was a recent news where an AI generated band got 1 million plays on Spotify. Now, what's so special about it? There are many of them who get these kind of million views, right? But the speciality of this particular album was that it was done by the Velvet Sundown. That was the group, that was the album team that worked on it. And it was an end to end AI based album that they had released. So, right from framing lyrics of the song to composing the song to music images that they used and everything else relating to the album was AI based. And this was uploaded also on Spotify, and apparently this got a lot of views, or it had a lot of listeners. But it so happened that those who were otherwise in the field of music were a little surprised as to who is this band. We had never heard of them before. And when they actually went back to check on this, they got to understand that it is a purely AI generated band. And this was not something that they had even, released an album by themselves. There was no original work anywhere in the past. They were not anywhere on the internet, or they were not even known in the past. So this raised a hue and cry in the music industry, saying that if you are coming up with AI generated music, you need to at least warn the listeners that it is something to do with AI, or that this was an AI generated music, right? So now music insiders say listeners should be warned. That is what it said. This was the highlight of the particular instance. And then there have been instances that you might have come across of something like Claude's training module, right? So we talk a lot about AI, and we talk about fair use. Many of you here in the room are lawyers. So if I'm to talk to you about something like fair use, we all understand. So we also understand that if I'm using a particular documentation for the purpose of training my AI, which will in turn give me something else, it is very transformative in nature. So if I given details of, let us say, certain documents, it is transformative. It will give you something else. It will give you a summary of something, or it will do something beyond what the subject matter is. Now, it so happened in this particular case that there was an AI training of the Claude's website. And if you just take a look at this here, the firm, that is Anthropic, had access to more than something like 7 million pirated books through a central library. They were using these pirated books for the purpose of training their AI. But this was the case. This was raised as a very serious issue by the authors groups, right? And they filed a suit against Anthropic, saying that you have been using pirated books of ours, right? So that is where, of course, this was a case. This was a matter settled later between Anthropic and the authors. It was a settlement of something like 1.5 billion dollars that they had settled on in the context of copyright infringement. But what was the key takeaway of this particular case was that it sent a very powerful message to AI companies and creators, saying that copyrighted works from pirated websites is not good. Don't train your models using these pirated stuff, right? It's not a good idea, or it's not ethical to be doing something like this. Uh, you must have heard of Otter AI. Now, suppose we are running a session right now, and we saw a pop-up message which said your meeting has been recorded, and there's also a read.ai which is transcribing our data. Right? We are aware of all these things because it is popping up on our screens. But it so happened in some of the video conferencing tools that there's this particular artificial intelligence again, which is called otter.ai, which transcribes, which takes the recordings and transcribes and prepares, helps you prepare your summaries of meetings and minutes of meetings, etc., which is a very, very handy tool for meetings. But what went wrong here was that this Otter AI was embedded, was a part of a major video conference, of some of the major video conferencing tools, where they said the meeting is being recorded, but they did not pop up saying that you give consent to it being transcribed as well, right? So this was one of the other instances. Tesla sues former employees for allegedly stealing data, autopilot source code. So, this is something to do with trade secrets. This is again very, very important. Imagine a lot of data being taken away from companies today. It's a very, very serious issue for them, right? Because data is oil, data is money in the present time and age. If you have to develop anything around technology today, data is very, very critical, and especially with artificial intelligence. So Tesla had sued some of its former employees for stealing data. Trade secret disputes. There was a major dispute a couple of years back between a company called Jawbone, which was into your smart watches, and Fitbit, where had Fitbit, okay, some former employees of Fitbit had been possessing multiple trade secrets which were stolen by from Jawbone. Again, another major issue of trade secrets. So when we see all these illustrations, we sort of understand that there are new dimensions to the protection of intellectual property in the present digital age. I mean, these are only very, very illustrative that I'm telling you, just to understand what are the different dimensions we have and where we can start with our careers in IPR. Okay, it is not the age old conventional thing where we said a book cannot be copyright infringed or something like that. It's not just in the form of a physical subject matter today. It's a lot to do with the digital infrastructure today, right? That is what we need to be protecting. And a lot of questions do arise, of course. Why IP matters in this digital age? Of course, when we talk about intellectual property, we are helping our clients create value, right? Value creation. A lot of innovation that can happen. And then we also have competitiveness. It's a very, very competitive world today because the pace at which digital technology itself is growing is so very fast that adapting to it and trying new innovations around it in itself can be very, very competitive. We also need IP context with respect to trust and protection. Protecting the interest of the parties. So I'll talk about that a little later. But it is also important in terms of monetizing, managing risks, new frontiers, exploring new frontiers in the field of digital economy. So these digital technology. So these are some of the things that make it far more relevant for us in the context of intellectual property in the present time and age. That's what I was just mentioning. A couple of years back, or maybe about 1-2 decades back, we were mostly concerned about protecting books or something which came in the form of a CD format, like downloadable versions or some patented machines. But today we have a lot of digital assets in the organization, which includes your ebooks, e-music, gaming, cloud-based services, software programs, metaverse, and a whole lot of these things, which are the talk of today. What has all these done to us, or how has it impacted our intellectual property rights, or what are the challenges it's throwing us? Of course, when printing press came, the apprehension was a printer can duplicate a lot of copies. That's when the apprehension of technology into the multiplicity or reproduction of content came, right? We thought with printing press, a lot of issues can crop up, which is why we need to introduce something like copyright, something that can protect the interest of the owner or author of the work. Fast forward, look at things today. Even if we started with a couple of years back with the internet, what did internet do? It made distribution instant and global, right? We did not have barriers, but it also made infringement faster and harder to control. With respect to artificial intelligence, there are a few other dimensions to it where it can raise questions of authorship and ownership. Who owns it? Right? Like we saw the example of the album. Now, who owns this album? Who did it? Who made it? Is it because I gave all the prompts that I am the author, owner of the intellectual property? Or do I not own anything at all? Because there was nothing that I created by myself. That becomes a question. So the question again arises, who owns AI generated works? Right? Then came all of these blockchains, etc., which of course enables your non-fungible tokens, right, and smart contracts, etc. But in terms of creating new ways of proving ownership, who owns the data, who owns all of this through the layers of the blockchain, is a little more complicated for us to explore. With the coming in of social media or the prominence of social media in the present time and age, there has been a rapid content creation and sharing. Right? We say we share it across all social media. But there have been instances of use of this content in terms of memes, reels, viral posts, which is actually blurring this line between fair use and actual infringement. What exactly is happening? It might sound like a meme, but so many people watching the meme and they might be capitalizing on it, they might be commercializing on it. So these are some of the impacts that we are seeing. I mean, just pointers, but there's so much more to it. What are the challenges that we are facing in terms of copying, right? Copying, piracy, anonymity, and cross border issues. So, what are we seeing in the context of copying? A digital file can be cloned endlessly and at almost no cost. Yeah, you can make multiple copies of it. Piracy, streaming, P2P sharing platforms, they fuel massive copyright violations. Anonymity, infringers. Anybody could be having a fake social media account, or it could be just about anything where they make enforcement far more difficult to even find those people. Now, suppose even if they have pirated a lot of musical work or whatsoever it is, to find them and to hold them liable itself is quite a bit of a challenge. Cross-border issues. Laws, of course, they differ from country to country also. So what's legal in one country may be an infringement in another. Because, for example, parody, right? It may be legal in some countries. They have they have a right to free speech expression, but in some other countries, it may not be allowed. So these are some of the challenges also that we are facing in the context of the digital age. Software patents. So we look at it from the perspective of algorithms. Today, should we consider algorithms protectable? Apps, the various apps, business methods have to be relooked because we always read that business methods cannot be patentable. So, what is it that we can consider? What is it that we cannot consider? Because most of these are AI based business methods today and very innovative methods coming in. Abstract ideas, or should we consider them as technical solutions? So, these are all some of the questions we have. Uh, I don't know if you've all been reading about this, but Dabus it was an AI which claimed the inventorship, right? So this was an instance where Stephen Thaler had invented an AI generated invention. It was called Device for Autonomous Bootstrapping of Unified Sentinels. It was otherwise called DABUS. And in the application, in the patent application, Stephen had mentioned Dabus itself as the inventor. The question arose, the question came up before a number of jurisdictions of the patent offices like Australia, US, UK, in even South Africa, whether this patent, it was like a patent cooperation treaty filing, where the question asked was whether an AI can be an inventor. The US PTO, the UK PTO were very clear, no, this cannot be protected. This particular AI cannot be the inventor because we require a natural person to be the inventor. That is the law. But in South Africa, there was something slightly different. They interpreted it saying that we can grant patent to inventions generated by Davis. And therefore, this was supposedly on record a first patent granted for an AI invention. These are all available on the internet. You can just check them out, read them out of some further interest. When you look at trademark in the digital space, again, we are going through a lot of new dimensions. Like we said, graphical representation, we said, trademark name, logo, etc., etc. But other than that, domain names have been quite an important space. Cyber squatting, squatting, online branding, trademark dilutions, social media influencer marketing. These are all some new systems that have come in place, some new dimensions that have challenged the trademark mechanisms in across the world generally. Some copyright concerns in the digital age, digital works which are in the form of ebooks, music, films, software, etc. It can lead to piracy, peer-to-peer sharing, streaming services, and like I just mentioned, some of the new issues being memes, user generated content, AI generated works. Should it be protected? Should it not be protected? So these are some of the concerns we have as far as the digital content is concerned. So, what is our learning out of all of these? The most important thing is we need to now relook at it. The intellectual property is not going to become obsolete. It's going to be far more challenging. It is going to be far more important and relevant in the present time and age. Uh, just for you to know, India stand as early as 23-24 itself. The statistics showed that India stands at top position 4 in the context of trademark filings. We have been filing almost like 5 lakh trademarks per annum, per year. That is the quantum, that is what we are doing today. And 2024 also marked something like 1 lakh applications, patent applications before the patent office. This has been the volume that we are seeing in the context of IP protections in the present times. Interesting times ahead, I would say, and I hope this presentation has given you an insight as to how important intellectual property is in the present time and age. Now, a small introduction also, because we have the subject itself, the masterclass for today also talks about careers, IP careers in the age of AI. Of course, the very first thing that we will all have to grapple around and we'll have to sort of really research around would be the context of identifying the right kind of intellectual property and finding the ownership. That is the first thing that we will all have to, work a lot around in the context of policy, research, and even in the litigation space, we'll have to work around a lot of all these things, right? Or even in terms of consulting, legal consultations to our clients. We'll have to consider all of these, equip ourselves better off, in terms of advising them in this context. The second very important thing that we will all also have to do as lawyers is to understand, at least have a basic understanding of what AI architecture is all about, because we will have to also work around policy and ethical aspects of artificial intelligence, right? So, for example, if somebody is developing around an AI, we'll also have to delve a little deeper in the context of seeing how this mechanism works, and is there a likelihood of a data breach, and what is most likely to happen, right? So these are all some things that we need to understand ourselves in the context of AI, IPR, data protection, etc. They are all hand in hand. They are not very different subject matters today. They are all very interwoven in the context today. For those practitioners, enforcement issues is something that we'll again have to consider. So maybe it's not just litigation, arbitration, mediation, cross borders, and various other things will also have to be considered. So these are, again, like I mentioned, for corporates, IP cells having their own respective IP cells, the legal counsels will also have to equip themselves with not just understanding the basics of IPR, but also in the context of protecting the interest of the company and identifying the right kind of IP in the digital age. So these are some of the things that I would, so that I just wanted to highlight during the session. And coming to the subject of IPR itself, so we have the way this course has been defined, the 6 months course has been designed also is keeping in mind law students who are coming out of their law school learning and transitioning into their areas of practice or maybe an IP practice. Or it is also useful for those lawyers, practitioners, legal counsels who have done IPR in the past but want to brush up your skills so that you will be able to enter the field of IPR through your practice and learnings, right? So suppose you want to venture, you've been practicing on the civil side or also on the commercial side, and you might be having some cases of late relating to trademark infringement or copyright infringement or patent or related, or anybody is asking you about all of these things. So you should be equipped enough to explain to them about all these things. So we just kept all these in mind while we were designing the program. It will this the program will start with, so Dr. Anshul has shared about the course learnings. You can go very much in detail on each of these things, but I just wanted to help you understand how it is structured, what are the different modules that you will be covering. Number one, we'll be covering, we'll start with an introduction and help you to identify intellectual property itself, to identify the forms of intellectual property, how these, some very interesting stories around how IP evolved at all, how patents, because none of them have come together. It's not like the Indian Contract Act, or if you call it the Companies Act, which is just one enactment. Now, intellectual property rights is a bouquet of enactments. You have Patent Law, Trademark Act, Copyright Act, Designs Act, GI Act, etc., etc. So they have all come up in their own silos, and they have come up at their own times. So it would be very, very interesting to understand how they all evolved, a little bit of jurisprudence and evolution of the IPR as such. And then we will be moving into the core of the subject, where we'll be delving quite in detail with respect to patents, trademarks, copyrights, designs, geographical indication, plant variety, trade secrets. So we'll touch upon each of these forms of intellectual property quite in detail, including the registration processes, etc. And we will also look at the commercialization dimension of it, because many of you practitioners might have to, draft a lot of contracts, IP related contracts, like for example, a licensing agreement or a content agreement, right? Or it could be just about any of these things that you might have to prepare for your clients. So we'll give you some insights, not necessarily that we'll teach you all about how you draft each of these forms of contracts, but an insight into what needs to be looked into when we discuss about IP contracts, or what you have to equip yourself in terms of IP contracts. IP management is another very important part. So you can imagine large firms who have to manage a lot of their clients' intellectual property, or a company like maybe one of the multinational companies or whatsoever, where they hold a lot of intellectual property. Suppose you are the legal counsel for, say, Samsung or Netflix. The number of intellectual properties are so much more, right? So to manage intellectual property within the organization itself requires a lot of a lot of discipline, a lot of process in place. That is what is IP management. How do law firms, how do companies docket in such large volumes of intellectual property? How do they manage renewals? How do they manage registrations? How do they manage lapse of these forms of intellectual property? So these are all some things which are very, very interesting and very important for you to know. And of course, we will, as it is a subject of law, we will also touch upon the infringement and enforcement aspects of intellectual property rights. What constitutes infringement? Uh, how is the enforcement actually being done? What are the laws? What are the provisions as far as India is concerned in the context of protecting the interest of an IP holder? So these are some things that we'll be looking into. Lastly, we are also going to touch upon some sector specific, like for example, what is intellectual property from the perspective of healthcare? What is IP from the perspective of entertainment and media? Right? What is IP from the perspective of data protection? Or if you have something specific that you want to learn about, we can also organize some live sessions on that. So, in the context of your pedagogy of learning, we will be sharing some, not some, many video lectures with you on each of these topics, each of the modules that I just mentioned. So you will be taking these modules. You are supposed to have, sort of prepared yourselves on these modules. It's like a pre-read for you all, going through these video lectures and understanding. And once you have, I mean, as you progress with your learning, we will also have some live sessions, right? Every now and then we will have some live sessions which will cover some of the key topics. And we have some really, really, experienced lawyers who come and talk about their experiences in the IP practice, be it drafting IP contracts or IP management or whatsoever it is. As you have also seen our brochure, we are knowledge partners with three very well known IP law firms, that is RSR Legal, we have Lex Orbis, and we also have allied law practices. So they have all been extremely, they're very, very experienced in the field of intellectual property rights, and they have been with us as knowledge partners. So we will have some of them coming and sharing their thoughts and experiences on intellectual property rights. So overall, this 6 months is going to be, I wouldn't say quite a rigor, but it's going to be a lot of learning in the context of IPR. So with this, I will just close on my presentation. But if Dr. Anshul has something else to share, and also from the team, from the group, right, from the participants, we would like to hear more from you. Or if you have some questions to ask regarding the subject, I'd be happy to share.
You can ask us any questions regarding the structure of the course as well. The course is divided into 2 semesters. We would be having the live sessions in between both the semesters. There would be a one end-term exam and one project assignment as well. So I'll just share my screen and I'll just show you that once you register with us, then what all you will get in terms of what Dr. Pratima has already explained. So these are the courses which are part of the program. We have Introduction and Evolution of IPR and the basics, patent, trademark, copyrights, design protection. All these are included, including the IP contract drafting, intellectual property management, and sector specific as well. So you can. I'll just show you how the course looks like. So when we just this is copyrights. So these are divided into various units. This is module 4 for copyrights, in which you will get to read, and there are some videos also along with the materials. These are some exercises and some suggested readings that are also included here. So once you go through the course, you'll be advised to do the exercise simultaneously. Once you're done with all the exercises, the certificate will be issued for particular course. This IPR has almost like 8 to 9 courses, in which we expect you to complete all the courses, including the exercises. It's included also we'll be including one live classes and assignment course, where all the live classes details will be there. In case you miss the live classes, the recordings would be available within 24 hours. And also, as I've already told you, there will be one project assignment to be submitted and one end-term exam. The course we are going to start on 1st of January, and the end date is 1st of July. And yes, we are running an offer in which you get 2,000 off, and the 13,000 is the price for this early bird offer. So just let us know in case you are interested, and also let us know if you have few questions for us, because I'm sure Dr. Pratima, you missed introducing yourself. So Dr. Pratima is the project director for this AIPR course. She's editor with EBC Learning, and she is the one who conceptualized this course at EBC Learning. So please go ahead and ask any questions you have it right now for us. You can put it in the chat box as well. Teams, you guys have no questions regarding the session or anything regarding the course structure for IPR 6 months course. Okay, so details I have already shared with you all in the chat box. And just get in touch with us in case you are interested in taking up the 6 months IPR course. And yeah, thank you very much, everyone, for joining. Thank you, Dr. Pratima, for the wonderful
Thank you.
session.
Thank you.
And
I hope it
yeah,
was useful for the participants as well. And do consider taking the course. Thank you.
thank you. Yeah, thank you. Have a nice evening ahead. Thanks. Bye bye.
Thank you. Bye.